Sen University. We are blessed to welcome Shri Suresh Gupta Sir, Chancellor's nominee, Maharaja Agar Sen University. Sir is absent today for his prior commitments, but Sir has sent his best wishes for the event. We are grateful to welcome resource person of today's session, Ms. Sangeeta Manohar, Patent Agent and IP Consultant, Chandigarh. We are happy to welcome Dr. Pankaj Nagalia, Registrar, Maharaja Agar Sen University. We are pleased to welcome Professor Dr. Aparna N. Mahajan, Director, Maharaja Agar Sen Institute of Technology. Also, I am deeply grateful to welcome faculty members, dear students, for privilege of their company in this session. Dear participants, the primary objective of today's workshop is to provide you with a comprehensive understanding of intellectual property rights, which refer to legal rights that protect the creation, innovation developed by the researcher. This includes inventions, literary and artistic works, symbols, names, and images used in commerce. By protecting these creations, we can ensure that individuals and organizations responsible for them are able to benefit from their use and prevent others from using them without permission. To proceed further, I would like to invite Professor Dr. Aparna N. Mahajan, Director and President IIC, Maharaja Agar Sen University, for briefing the workshop. Ma'am, please.
Thank you, Shilpa. Good afternoon to all. Honorable Vice Chancellor Sir, Sri R.K. Gupta Sir, Chancellor's nominee Sri Suresh Gupta Sir, Registrar Dr. Pankaj Nanglia, today's eminent speaker Mrs. Sangeeta Manohar, Patent Agent Chandigarh, all directors, faculty members and students. Due to some connectivity, I am switching off my camera. I'll continue. Today's IPR event comes under our IIC 5.0 as a last quarter event. Till now, during past 4 to 5 years, we have conducted, this is 10th event on IPR in a row. This is the event which is mainly focused upon the IPR or focused on how it is used for startups and entrepreneurship. Mrs. Sangeeta Manohar, she is a patent agent. She has been guiding our 2 patents from our university. I am thankful to you, ma'am, for guiding us, and I'm thankful for your time because this event has been postponed twice because of this natural calamity. So I acknowledge your presence today, and thank you, Shilpa. Thank you. Over to you.
Thank you very much, ma'am. Now I would like to invite Honorable Vice Chancellor Sir, whose visionary leadership has been instrumental in shaping our institution path towards excellence, to address the gathering. Sir, please.
Good afternoon, everybody.
Good afternoon, sir.
I heartily welcome our today's keynote speaker, Madam Sangeeta Manohar, who is patent agent and IP consultant from Chandigarh. Shri Suresh Gupta ji, our Chancellor's nominee, Dr. Aparna Mahajan, Director Mates, my dear faculty members and students. We are happy that Madam Sangeeta Manohar has accepted our invitation to deliver expert lecture, which is being organized by our Institutional Innovation Council.
Yes, ma'am.
As a university, we are committed to advancing knowledge and innovation through research and development. This often involves creating new technologies, processes, and products that have the potential to benefit society in countless ways. However, in order to fully realize the benefit of these innovations, it is essential that we protect our intellectual property rights, which refer to the legal rights that protect the creation of the human mind. Also, I congratulate Dr. Aparna Mahajan and her team to organize such activities, and I hope this workshop will benefit the faculty and student community and give them a brief idea about IPR. In conclusion, I want to emphasize the importance of intellectual property rights in advancing knowledge and innovations. By protecting our creations, we can ensure that they are used for the benefit of the society and that researchers and innovators are able to continue pushing the boundaries of science and technology. I hope the Madam Sangeeta will cover all the aspects during this workshop. Thank you for your attention. Thank you very much and good luck, everyone.
Thank you very much, sir. Now we have among us Ms. Sangeeta Manohar, patent agent and IP consultant, Chandigarh. So without taking much of your time, I would like to call Madam Sangeeta Manohar to kindly address the audience. Ma'am, please.
Uh, Good afternoon, everybody. It is a
Good
pleasure.
afternoon.
It is a pleasure to be here this hour to tell all the students and to make them understand how to file and draft a patent. But before we start, I must thank Professor Dr. R.K. Gupta, Vice Chancellor, Maharaja Agrasen University, and Shri Suresh Gupta ji, Chancellor nominee, for giving me this opportunity. May we begin?
Yeah, you can proceed, please.
See, to all the faculty and the students who are present here, I would like to introduce myself as Mrs. Sangeeta Manohar. And my basic qualification is that I did my master's in microbiology from Punjab University way back in 1987. And I just want to tell you the importance of this degree, which made me eligible to take the patent agent examination 30 years later in 2019, when I was then finally appointed as the patent agent at the Indian Patent Office. So what I'm trying to tell to the students today is how important is education for all of us and how it comes to your help at any order, and a degree which I had earned 30 years back has come to be fruitful today. So this is my request to all students and advise that take your work very seriously because it takes you very far. Your education takes you very far. I, as a patent agent, will first want to discuss what basically the drafting of patent applications. So before we start, I would like to show you what a patent certificate looks like. After you have been granted a patent by the government of India, this is what a patent certificate looks like. If you can see on an enlarged version, the patent number is granted only after the grant of the patent. So whenever we file a patent, we get an application number, which here is 2021111004175. And once the patent is granted, then we get another patent number, which is 391378 in this particular case. This was a patent filed by us, by me and my team member. And what is most crucial in this case is the date of filing, 30th January 2021. And why I want to tell you this is because this date becomes important, because your patent becomes is applicable from this date for the next term of 20 years from the date of filing. So that is 30th January 2021. So this patent will be with Dr. S.K. Sharma, Surinder Kumar Sharma, who is the inventor in this case and is now called the patentee. And it will be for a term of 20 years. This patent certificate also mentions the title for which the patent was granted. And it says a vacuum system and a method thereof. So if we go on to the next slide, you might think that this is simply a picture taken of any random place, but this is actually the invention of the inventor, Dr. S.K. Sharma, who is now, of course, retired, but was at one point of time the head of Department of Chemical Engineering, Punjab University. So this is his patent, this is his invention. And if you see that there are two tanks, can we all see that? And in the two tanks are connected to each other and with pipes, and there are valves at various points. There are valves which are visible at various points. This and this. And there is a barometer, an instrument which will measure the pressure inside this tank, which will be a tank in which vacuum is created. The idea behind this invention was that no vacuum pump was used to create a vacuum in such a large tank. This is the novelty of this invention, and for which he was granted a patent. If we start with the drafting of the patent, since we all understand what we are going to talk about. So every patent application, if it needs a drawing, has to have a drawing. So in this particular case, we have two reservoirs, two tanks, and both the tanks are connected with pipes to each other. And I also have many valves. There are a total of 5 valves used in this case. And one of the tanks is connected to a reservoir which is filled with water. So in this particular invention, Dr. Sharma had tried to create a vacuum, has created a vacuum using water without the help of any expensive liquid metals like mercury, and without the use of a vacuum pump. So if we see a drawing which is mandatory for such an invention and has to be a part of a patent application, it is very well labeled with the numbers which will be explained later in the invention. So this is the drawings become a very important part of any application which has to be filed at the Indian Patent Office if it is required. Let me come to this particular form, which is called Form 2, where I want to show that in this particular case, the title of the invention is mentioned, which is a vacuum system and method thereof. Generally, we try to keep the title very short, unlike in a publication, not divulging too much, and it should be not more than 10 words. Sorry, 15 words. The title should not exceed more than 15 words. The Form 2 also mentions the applicant, who is Dr. Surinder Kumar Sharma, and we go on to the filing of the patent then. Another part of the application which we would like to, which we have to mention, is the field of invention. Now that we've understood what the invention is all about, the controller who is looking at your application wants a brief understanding of what your invention is. So we mention the field of invention, and in this particular case, we always start this field of invention by the following line: the present invention relates to a system to generate vacuum in a compartment of any size. It particularly relates to a device which involves the discharge of fluid from a closed enclosure to create vacuum, eliminating the use of energy-intensive vacuum pumps to create a vacuum. What we are trying to do in the field of invention is we are giving the most important points of the invention. So that is to generate a vacuum, first thing, a system to generate a vacuum in a closed enclosure without the use of vacuum pumps. Then another heading that comes under the drafting of applications is called the background of invention. In the background of invention, we always mention the problem that we are going to address and the solution our invention will provide. So that is what a background of invention will include. So we have various technologies which have been used to create vacuum, something like a vacuum pump, and others like, and we always mention the importance of creating a vacuum in the present environment. The second part we have also mentioned as part of the background of invention is the prior art. By prior art, we essentially mean what has already been published in the public domain and to which either patents have been granted or other published literature which is available to any person interested in vacuum technology. So here I'm mentioning in prior art, I'm mentioning two patents. We mentioned the two patents, US 8540688B and US 103591311. These two patents were written by us, chosen because we wanted to show that our invention is novel and it does not use any vacuum pump, because a vacuum pump generates a lot of heat and requires a lot of energy, electricity for operation. Then comes the objectives of invention, which is also a heading which is included in our patent application. So objectives of invention, in this we essentially tell the controller and disclose them why we want to create, what is the purpose of uh, uh, creating this invention. So the main objective of this invention, if I read it out, the main objective of the invention is to provide a system and a method to reduce pressure of the area of any dimension. It is to create ultra high vacuum in restricted area of all sizes. It is also an environmental friendly solution to vacuum generation, and it also provides ease of performance, installation, operation, and control of vacuum system. So what by objectives, we are essentially trying to tell why we have created this invention. To circumvent all the problems that are faced in the industry when creating a vacuum. Another aspect of this is the summary of invention. By summary of invention, we give them a gist of the entire invention, where we are talking about two chambers. One of it is the process chamber, the other is a vacuum compartment. There is a water reservoir, there are pipes which draw water from the reservoir to the chamber and back. There are pipes to connect the two chambers, and there are water valves which can be closed and opened when required. So this is what is essentially the summary of invention, which is a very important aspect of an application. After which we come to the description of invention. In this particular case, this is a very important part of the whole specification, of the whole application. And this actually describes the figure or the drawing which we had made in the first case. And it will exactly tell the inventor, the controller at the patent office, as to what it is all about. So we refer to the figure 1, and all those numbers that were written on the drawing, which I had shown earlier, have been explained, and the process has been explained in this particular embodiment. Embodiment means a physical form of the invention. So if the invention were to be made by any person interested in creating a vacuum, then this is what the embodiment can be. An exact embodiment cannot be copied, but subsequent embodiments may or may not be copied, but will give an idea to a person interested as to in what other manner can the same invention be performed. Embodiments. See, now this is a very important aspect of the patent application, where the inventor is trying to protect his invention, so that just in case, for example, in this particular case, the inventor has used water to create a vacuum. However, he also wants to safeguard his invention by mentioning that water may be replaced by liquids such as mercury, indium, or other metal alloys which have solidification, which have which are liquids at room temperature. Then also the inventor has tried to protect his invention by mentioning that the liquid used can be not just pure water, but it can have various solutes and suspensions, and also some more other embodiments can be incorporated in an invention so as to protect the invention from being copied. This is entirely on the inventor to and the patent agent to draft a particular invention in such a manner so as not to be copied or to prevent others from copying the invention. So embodiments actually help the inventor to protect the invention. Then, see, this is a very important aspect of a patent draft, is that a patent can be drafted either on a product or on a process. In this particular case, we are patenting both. We are patenting a product as well as the method of operation of the system. The method of operation can be in one word called process, and the product can be called the drawing or the figure which you had seen earlier, which is a vacuum system. So we have in our previous slides described what a vacuum system, what this system of this vacuum system comprised of. And now along in the complete specification, we must provide what should be the process of operation. So we actually in detail explain the process of operation, because we must understand that the controller who is at the Indian Patent Office may not be convinced by your invention. So he will keep raising questions about your invention, which you have to adequately answer, and also has to be incorporated in the application. I mean, you cannot at the controller generally always, not generally, but always calls for a hearing before a patent is granted, where he comes face to face with the inventor and puts forth questions and doubts which he has about the invention. For example, this particular invention hasn't been heard of, and is a very out of the box thinking of creating a vacuum without a vacuum pump. The controller there was an expert at vacuum technology. We had, instead of one hearing, we had two hearings with the controller, and finally, when the controller was given appropriate answers by the inventor, that the controller was convinced and he granted us a patent for this invention. So what is important in our patent application is the draft, which must be in a detailed, which must give every detail of the invention so that the controller at the other end can understand the entire invention clearly. So in this particular invention application, we are drafting both the product as well as the process. Now, claims. Claims are very important, and they form a very, very important aspect of the invention. And if you clearly see, we always begin claims by we or oblique I, we claim or I claim, which means whatever is given below belongs to me and is being written by me, and is to every word of the claim is correct and truth. So we have to draft claims very carefully. What I'm showing you is an amended copy of the claims, because the first copy that we had drafted at the initial filing was had to be amended as per the objections raised by the controller, and this is the final uh, format of the claims that were finally granted. So claims have and it is the controller has always objections to the claims, and what is important is that whatever is contained in the claims should also be mentioned in the complete specification, in the description, in the background, in the field of invention, wherever, but in the application. It should be a part of the application. We cannot claim something which has not been mentioned in the application. So, and this, if the controller by chance raises an objection to your claims and says that you haven't mentioned this particular aspect in your complete description, then uh, the controller also gives you a chance to amend your application, which means by which you can add certain points which you could have probably missed writing in the application. So in this particular case, if we say the first claim is always called the independent claim, which is the main claim on which the rest of the subsequent claims will be based on. So we say we claim a vacuum system comprising at least a liquid reservoir, which means one reservoir, a pump, a process chamber, a compartment, at least 5 valves, liquid carrying sources, which means pipes, and a vacuum line, wherein the liquid reservoir is connected to the pump, the process chamber is further connected to the liquid reservoir, and at least one, and we are describing the various purposes of the valves and the liquid drains or the liquid carrying sources. So this is called claim 1, which is independent, and it has to be very, very narrow, which excludes all prior art. And because what you may mention in claim 1 should not be in any claim of any other invention or any other patent. So your claim, independent claim, should be very unique, and it should be typical to your invention. So claim 1 is always an independent claim. Then claim 2 and subsequent claims are called dependent claims. Dependent claims, by dependent claims, if we see the claim 2, which says the vacuum system as claimed in claim 1. If we see claim 3, the vacuum system as claimed in claim 1. So claim 1 becomes the main claim or the independent claim on which the subsequent claims are based. The patent office generally wants not more than 10 claims, after which it applies a fees for more claims more than 10. So we restricted our claims to 9, and then the controller asked us to clear off some 2 more. So we eventually landed up with 7 claims in our patent application, and all of them were dependent. One was independent and the others were dependent claims. Nowadays, however, there is a new practice going on which says the device claim and the process claim should be 2 independent claims, and they should form, I mean, there can be 2 independent claims also, one for the device and one for the process of operation. In this particular case, however, the controller had no objections to having one single claim, so that is why we have just one single claim. See, the 2 prior 2 claims, which were 2 and 3, were talking of the vacuum system as mentioned in the claim, as claimed in claim 1, and which means they were discussing the product, and claim 9 was the method of working of the vacuum system as in claim 1. So this was the claim which defined the method of working. So which has to be very clear to any person who is interested in vacuum technology and who has prior knowledge of this subject, to be able to understand every aspect of your invention. Another important part of your complete specification is the abstract. The abstract in a patent application differs from an abstract in a publication because it does not want to address anything else other than the invention. And it generally begins with the present invention relates to. So it will give you the advantages of the invention and an energy efficient, environment friendly, and cost effective system. It tells you that it has without any significant power consumption and without the use of a vacuum pump. It also briefly in one single line tells you about the invention. So the abstract should in patent applications be not more than 150 words, and it should give the controller or the reader give a brief understanding of the entire invention. An abstract should be very clearly worded. Every word of the abstract becomes important and should explain the invention, give the advantages of the invention, so that a person reading the abstract gets an overview of the entire invention. If I think this is what a brief, I mean, it's very hard to actually explain what drafting is, and drafting needs a lot of practice. I mean, to draft your particular invention. I think I want to open the camera.
Jo.
Yeah.
Shilpa, you may carry on, please. Thank you, Sangeeta ma'am. Be
yes,
online, ma'am. Be online, Sangeeta ma'am, for a while.
Yes.
Thank you so much for your special time. Thank you.
Thank you.
Shilpa, carry on.
Thank you so much, ma'am, for giving your valuable insight on IP and its drafting. I must say it was very wonderful and informative session. I hope it will be very encouraging for our students as well as our faculty members. Now, I would like to invite Engineer Kunal Singh to present the vote of thanks. Sir, please. Kunal, sir.
Before the vote of thanks, I would want the audience to ask me any doubts regarding the drafting of this application. Although it was very brief, but I would like to express that this requires a lot of practice, and any person who wants to draft his or her own patent can go through similar patents at various patent sites like the Google patent and IP India .nic.in. These are the two sites where one can read.
Sangeeta ma'am, sorry to interrupt you. Please, can you unshare your screen?
Unshare. I can.
Ma'am, first, please unshare your screen. Yes, ma'am. Thank you. Then I would like to ask from the audience section if there are any queries from you. If you want to ask any
question,
I will be
asking first question. The reason being, actually, the title given by IIC is IP management for startups. Whatever so whatever drafts we are making through you, maybe from somebody else. So normally they are basically focused on just patents. When we talk about IPR management for startups, how much is the difference between that? For drafting?
See, IPR management for startups, I wish you had given me this topic, but the little which I can tell you about is that IPR for every startup, they must show the investors that every startup has to pitch his product, because he has to invite investors to invest in their product. So an investor will only invest in the product if the product is unique and is very beneficial to society and has many advantages. So if the inventor if the inventor of a startup or the startup owner tells the investors about his invention, but has no way to prove that this is a fact what he's talking of is a fact. The investor may or may not invest in him. So we have startups here I'm working with startups which have filed patents through me, and everywhere they go, the person goes. His name is Dr. Sudeep Ghosh. He has a startup which is called Brew Therapeutics, and he is making plant-based hair oils and plant-based hair conditioners, which are effective for dandruff and hair growth. So, but he is pitching his invention at various platforms, but however, he's not able to convince the investors about the startup, about his product, because his patent has yet not been granted. That is why a patent granted for a startup helps the startup to convince the investor about his investment in the product which he thinks will be useful. Am I? Does that
Yes,
make things clear?
Yeah, ma'am. Thank you so much. Thank you.
Yes, ma'am. Another question I have received from the participant is, how can we avoid infringement on someone else's IP right?
Avoid infringement.
Yes, ma'am.
So it is very important to avoid infringement. For that, a thorough prior art search is required. A prior art search means that we look into every document, every publication, every patent which has been granted related to our own product or process. Then only can we stop. If we have it is a very interesting example which I want to give you, which we came across some time back, was that there was an inventor who came to me and he said, I have designed a kit to detect the presence of antibiotic resistance in microorganisms in patients in clinical samples. So we did a thorough prior art search, and he was actually looking at a gene called the OXA gene. And we went through all the literature, and we realized that there has been a lot of work which has been done on OXA gene. And the work that he had done was very similar to the work that already existed. So I advised him not to go forth with an OXA gene for antibiotic resistance, but try some other genes which might not yet have been discovered, or on which very little work has been done. So that is how we prevented infringement. Otherwise, our patent wouldn't have been granted if we had gone forward with the OXA gene, because for that there is already a patent which exists, and there is a lot of prior art which exists on OXA gene. So even we would have got lots of objections at the level of the controller to not go forward with this invention. So it is very important to prevent infringement. I won't even call it infringement, but I would call it, because infringement occurs only after the patent is granted. But what we have to ensure is that our work is novel, new, nothing exists prior to this, similar to our work. And secondly, if there exists something similar to our work, we have to show to the controller that our work, that we have done something which others have not done, and which has increased the advantages of the product or the process. Right? I hope I answered this question well.
Yes, ma'am, you have answered it beautifully. Thank you very much for your kind answer, ma'am. Now, I would like to invite the engineer Kunal Singh to present the vote of thanks. Kunal.
Thank you, Dr. Shilpa. It is my privilege and honor to extend the vote of thanks to everyone who has contributed to the success of this event here. First and foremost, I would like to express my sincere gratitude to the Honorable Vice Chancellor, Professor Dr. R.K. Gupta sir, for gracing us with his presence and unwavering support. His guidance and leadership continue to inspire us all. I would also like to extend our gratitude to Shri Suresh Gupta ji, our Chancellor's nominee of Maharaja Agresyan University, for his never-ending motivation and encouragement to conduct such events. A special note of appreciation goes to our guest here, Ms. Sangeeta Manohar ji, for delivering an insightful session on intellectual property rights. Her engaging presentation has undoubtedly enriched our understanding of this crucial subject of intellectual property. Thank you very much. We are truly fortunate to have the guidance of our respected director, Dr. Aparna Mahajan, whose vision and dedication have been instrumental in organizing such informative sessions. And her mentorship is always greatly appreciated. Last but not the least, I extend my thanks to our dedicated faculty members and all the enthusiastic students here. Whose active participation has made this event a success. Thank you all the students and the faculty members. I would also like to express my gratitude to each and every one for you who have contributed to this event in various capacities. Thank you all. Thank you all for this event.
Thank you,
Hello,
Sangeeta ji.
before
Thank
we
you.
Before
See
we
you,
conclude,
see
can I
you
have,
offline in the campus.
Ma'am, just a minute, please. May I ask all the participants to please turn on your
Yes, put
cameras
on your camera.
to have a group photo? Please, every participant is requested to turn on their cameras.
संगीता
And
मैम
I
हम
want-
ऑफलाइन भी लेंगे, आपका ऑफलाइन भी बुलाएंगे. Just ये थोड़ा सा वेदर ठीक ठाक हो जाए, we'll have it offline as well. Yes.
No, what I want is, I want to
Yeah.
look at all the students, whoever present, and I want to know what their responses are. कुछ समझ आया कि नहीं, या सब after lunch बैठे हैं तो नींद तो वैसे ही आ रही है. So, I mean, was it fruitful, worthwhile, or was it just another presentation? Because it was boring, because it was entirely on drafting. But if people who are familiar with drafting would have well understood the entire thing. So I just want to know कि कुछ समझ आया कि नहीं.
Ma'am,
The
it was very
students.
brief, but it was very good presentation. We literally understood a lot of things, and we got many things from here, that how the title and the claims, dependent, independent claims should be written, and what are the aspects of writing those claims, and title and abstract and all those things. Thank you very much, ma'am, for giving us
Thank you
that
so much.
insight.
Right. Thank you so much.
Thank you everyone for giving us opportunity to take a group photograph. Now I'd like to say at last, please fill up the feedback form that will be provided in your chat box, so that e-certificate can be delivered to each and every one of you.
Thank you,
Thank you,
Sangeeta ji.
Sangeeta.
See you in
Thank you.
campus. Thank you.
Right. Thank you.
Thank you very much, all the participants, for your presence for today's session. Thank you.